contingency plan is, who's going to determine whether or not a witness motion is appropriate or not. Is that left up to the county manager to determine in relation to allowing access to expert witness fees and those kinds of things? All right, so there's other issues that kind of are incorporated within that whole gambit, I would say. But, you know, as a practical matter, like I said, the courts and the rural courts especially have very rarely, if ever, deny a request for expert witness in the amount that it's requested, and usually bump it up when it's necessary. So that's all I'm saying. Now, do we know that they've made a request for an expert? Yes, but we don't require that the defense attorney go so far other than to certify to us that it's a necessity, that they feel it's a necessity for their defense. And we don't even tell them that they have to tell us, what the purpose of the specific expert is, as long as they certify that it's necessary, it's a reasonable and necessary expense to the defense. Now, I suppose an individual judge can inquire further on an ex parte basis with that attorney to ensure that quote unquote it wouldn't be a frivolous expenditure. But I just don't know anybody who has done that from the rural bench recently. So I don't know what to tell you other than it appears to me that it's more form over substance. So if you get a statutory change, then I don't think any of us would have a problem if I got rid of that $150,000 that I'm spending every year out of my budget. It can go to the county manager or whoever else. I don't have a problem with that. Get a statutory change.
Ms. Fitzsimmons, I see you. I want to go to Chris G first, and then I'll come back to you. Go ahead, Chris G.
Oh, thank you. Yeah, let's not overthink this, but I'm not an expert in this area at all. All I would say is be very cautious about anticipating what they might fund this session, just because of dire straits the entire state's in. So if you need to fix it in the reg rather than just saying, oh, well, we'll try to get some funding for it. Just my thoughts.
Okay, thank you. Ms. Fitzsimmons, go ahead.
All right, just my concern, maybe I didn't express it adequately in light of Judge Schmengelnich's comments. If I have a case that the main witness for the prosecution is a pathologist, and I just go to some judge and I say, please give me money for a pathologist. And if that's granted, which I'm hearing it always is, and I don't call that pathologist, but I go to trial, the judge is going to know that the prosecution witness is unimpeachable or their, testimony, whatever. That's not fair, because that only applies to poor people who are represented by appointed counsel in rural counties in Nevada, because we've just heard that Clark and Washoe don't do that. So I'm not saying that these things that judges are being nosy. I'm not saying that they're being cheap. What I'm saying is, objectively or subjectively, that puts our defendants at a huge disadvantage.
But what if you're in a WITIS situation? So it's the same thing. You come to me in a WITIS case, and private counsel files a motion. Hey, judge, I need an expert witness. My client can't afford it, and I need a pathologist. And then that pathologist is not called to trial. I mean, the part of my job as being a judge is being able to separate what the evidence is that's submitted during a trial and what's not. So basically the whole premise, I think, like I said, I believe it's a lot of form over substance. Get rid of the get rid of the provision in that statute that says subject to approval by the district court, and there would never be a problem. Remove it from, get the language removed from the statute. I don't have any problem if you do that.
Well, we'll work around that, but in a WITIS situation that you described, if you have retained counsel, but you're poor, that's equally, and if they can't afford their own experts, we don't want to open up another door, but it's the same issue, right? You have somebody who can't afford experts, and the judge knows that public money was paid for an expert and that expert wasn't called. I know that this is something that's been struggled with for years, and I just believe there's going to have to be a solution because this is fundamental to our mission.
I'm wondering if Mr. Hickman and Ms. Reba, you have enough. Oh, I'm going to call on you, Mr. Christensen. I'm sort of trying to figure out whether you have enough to work with so that we have enough feedback so that we can move on. But go ahead, Mr. Christensen.
Just to answer Laura's question, and here's what we do in Clark County for WITIS situation. The private retained lawyer will seek the court's order of whether their client is indigent, independent of the funds that were paid for their retained service. So that's the order I need to trigger my evaluation on what experts or investigators they need. So the order that goes to the court in Clark County on a private retained case just says, Judge, find my client indigent, and we've provided a form that we provided the bench that was consistent with that definition of indigency to allow the court to walk through an affidavit on whether they felt comfortable, even though they had retained counsel, are they indigent? And so the court, if they agree, will just sign off, the defendant is indigent for purposes of WITIS money. And then I'll look at that order similar to any other appointed case and make some determinations. So Laura, just to answer your question, in Clark, even in the WITIS case, the court won't be aware of what ancillary services have been utilized unless they were noticed and called it proper.
So I think what I'm hearing is that, that there may be a need for a statutory change, but also that there may be workarounds that can be done in terms of forms or draft orders that actually might alleviate the problem. Ms. Reba and Ms. Hickman, do you feel like you have enough to work with right now?
Yes, I think so. I do have one question, though, for the board to perhaps go back and take another look at the language in section 23, 1, the old section 23(1)(c) from the LCB file, and see if that comports more with the direction the board wants to go.
Okay.
Can you read it? Sorry, I didn't print that.
I sure can. It reads, a plan for the provision of indigent defense services must exclude the judiciary from the payment of attorney's fees, investigative fees, expert fees, and other case-related expenses for public defenders who receive a salary and public defenders who are independent contractors. If a county uses public defenders who receive a salary, the county shall create a budget for such expenses within the office of the county public defender that is subject to the administration of the public defender. If a county uses public defenders who are independent contractors, the county shall create a budget independent of the judiciary to be administered by the department or the designee of the department and include a mechanism of judicial review for any modified or denied request. If a public defender is disqualified from providing representation, county must follow the procedure for the payment of such expenses in accordance with NRS 7.115 to 7.175 inclusive.
Comments?
This is Drew. I like it.
This is Julie. My only concern is the department ready to handle that? Because right now, I do court-appointed, not criminal defense anymore, but I'm still doing 432Bs and things like that, terminations. But and every one of them, I think, White Pine, Eureka, Lander, Humboldt, Elko, all of them we submitted to the judges, our fees. So the department or the department's designee, if the judges are no longer signing off on those, there's going to be a lot of them.
The intent with the or designee or its designee language was to provide some flexibility for a county to create the office of appointed counsel or appointed counsel administrator if they chose to do that rather than have the department be involved. In terms of staff, I think we are ready to handle something like that, provided it's limited to the rurals. And obviously anything outside of that is going to be too much, and it's certainly not something we'd be chasing down.
And I think we could also include in the policy of our department that certain requests up to $25,000 or $2,500 would be approved. And that's what's commonly needed for substance abuse evaluations, mental health evaluations, things that aren't going to be denied, but you need to move quickly on. So maybe that could also be the policy that those are just automatically approved by us. But anything over that would have to come into a more rigorous process. And I would like to point out that in building Legal Server, yesterday, it did point out that if individuals are using Legal Server, there's a way that you can directly request funds for an expert through Legal Server, where they enter what kind of expert it is, what the expected costs, and it'd be immediately sent to our office. So there's a way to do that through the software program, if that's ultimately required for use by the rural counties.
Okay, Mr. Arascata, go ahead.
I would just, Mr. Hickman said as long as it applied to the rurals, I think Drew has already shared in Clark County, they have a process in place. We too have a process in place already in Washoe County, so that provision could apply to the rurals only.
Okay, are we able to push on? I think 26A you might have already described. That's the vertical representation. Am I correct on that? And
correct. We already
26B, and I know we have comments that came that we received on 26B. So I'm particularly interested in just hearing sort of what's been resolved and maybe what hasn't been resolved, as you explained.
Thank you. So 26B is kind of the answer to the issue we had in the client communication regulation. Rather than delineate a long list of specific attorney performance standards, subsection 1 seeks to incorporate the attorney performance standards in ADKT 411, consistent with what Mr. Wells had indicated at the outset of this in the definitional section. Section 2 includes some language regarding specific attorney performance standards that came out of Davis. And there's kind of been some internal discussions as to whether or not, that would be appropriate in light of subsection or in light of paragraph 1 to keep in, because ADKT 411, the attorney performance standards has similar language, just not identical. And for example, the Davis requirement that an attorney make reasonable efforts to meet with each client within the first 7 days and then every 30 days thereafter is a little bit different in ADKT 411. Those provisions provide for 72 hours for an in-custody client and as soon as reasonably practicable and sufficiently before any proceeding for, as the general standard or for out-of-custody clients. So there is some question about whether or not we should keep that in or take it out. The comment that we received with respect to this one yesterday from the institutional offices in Clark and Washoe came with respect to paragraph 3, and that is a provision in an employment or in an employment contract requiring compliance with the regulations. I will note that language came directly from 18320. I believe 2D2 and 2D5 is where that came from. And then finally, paragraph 4 deals with the client survey, required by Davis. And the concern that came from the cost of providing that and done with it in the larger counties. And I think the agreement that we reached yesterday, or the discussion we had yesterday, that the client survey is more of a an oversight tool and consistent with the department's oversight capacity in 18430 to counties whose population is less than 100,000. That provision may be amended to only limit that to. Additionally, the legal that Ms. Reba mentioned has the capacity of incorporating that into the system, so it's easily distributed, from that system as well. So another reason why there may be a limitation on that, just to the counties less than 100,000.
I'm sorry, someone wasn't muted and I missed probably 3/4 of what Mr. Hickman said.
Oh, okay. So I was also hearing turbulence in the background. Perhaps if you're not on mute, everyone could just mute themselves, and maybe Mr. Hickman, you could just repeat the last little bit.
Sure. So I guess with respect to subsection 4, we'll start there and kind of work backwards. The survey, the comment from the institutional offices in Clark and Washoe concern the cost and what concern the cost of providing that survey, and then where it goes and what's done with it. Consistent with the Davis settlement agreement, that survey is more of a more of an oversight management tool than anything else, and consistent with the department's oversight capacity in the rural counties in 18430. I think the intent behind that was that the surveys would be provided to clients in rural counties. The other thing I added to that was that Ms. Reba had previously brought up legal server. I would note that its capacity to provide these surveys is kind of built in. So, the amendment we discussed last night or yesterday afternoon would be a limitation of paragraph 4 to rural counties.
Maybe just, hi, sorry, I needed to unmute. Paragraph 3, can you just say something about that too?
Yes, so paragraph 3, and that was another subject, and if Ms. Thomas is still here, it may be beneficial to have her input on this. Subsection 3, a contract provision that requires compliance with regulations in the employment or other contract. That is language that came directly from the statute. It's in 2 places, 180-320 2D2 and 2D5, I believe. So that was wrapped into the regulations via that statute. I don't want to.
She's raising her hand.
Okay.
Yeah.
It looks like Ms. Thomas is raising her hand, so I think letting her explain her position may be useful here.
Go ahead, Ms. Thomas.
I absolutely think it's a management right to set standards and to require compliance with statute and Supreme Court rules and ABA provisions. I'm not disputing that at all. I'm just not clear about putting that in a collective bargaining agreement, and whether that's something that conflicts with Chapter 288. It might be possible to do it in a way that doesn't create issues, but I don't want to go to the EMRB to argue over this with employees. And that's my big concern, going back to days of being the union president, where I probably would have loved that provision. So, when I was fighting with my department head over an expert, I could just go to the EMRB and give it a shot to have them help me out. or when we're dealing with privacy issues for courtroom construction, jail construction. It's more about where are we going to address these issues. My guess is Jeff probably has some thoughts on this too, but there can be conflicting statutes. I just think that we need to be aware of the Chapter 288 ramifications of putting this into a collective bargaining agreement.
Mr. Wells?
So I agree with Jonelle. I actually think you almost have to divide this into two parts. You can do the contract provisions that we would have in our plan for our independent contractors when there is a conflict, that they would have to do it. But we can't put it in the quote employment contract, because the employment contract, at least down here in Clark, is with a collective bargaining group called the Defenders Association, and these are things that should not be bargained. These are things that are management rights that we can impose, and we never want to give up management rights and put them in a bargaining agreement, because once they're in, you never get them out.
Okay, Mr. Scotta?
Yeah, I would just add regarding 3, up here in Washoe County, all the attorneys are at-will employees, and if they're not following best practice standards, they're not practicing in my office or Mr. Picker's office any longer. We have that luxury. So I agree with Jonelle and Jeff from the bargaining standpoint. And then I'll just share anecdotally regarding client surveys. For I think it was 10 years, this office conducted client surveys. There was less than a 5% return on the surveys given to every client. And I discontinued it as a matter of course, because we weren't getting any data from it that's reliable based on the lack of return or reply. And I tend to think with the nature of our clientele that that would probably be the experience of the board regarding replies on client surveys.
Okay, very useful comments. I guess my question to you, Mr. Hickman, and to Ms. Reba is, it seems like on number 3 that like we just have to find some different language that kind of carves out the sort of individual case appointment contract situation versus, you know, the office-wide employment. So I think that's just a matter of trying to figure out what that is. And then, yeah, the surveys, I don't have any comments on that. So do you think you have enough to work with on that?
Yeah.
Okay.
So that,
oh, go ahead. Go ahead.
I was going to say that moves us into the next chunk. I didn't know if Madam Chair wanted to call for a break or anything to that effect, or keep going.
So I think we need a break. I would like to have it be a brief break. I think I am a little concerned about timing and losing our institutional defenders. So we can either work this out in the break or now, but my suggestion would be that we prioritize the sections that we anticipate in the order that maybe actually I should just ask Ms. Thomas, how would you anticipate the order? I think we could probably get through it all, but to the extent we run over, I don't want to run over on something that you're going to miss. So should we turn to 48 and 50?
Yeah, I believe that's the a huge priority for the institutional defenders, or 48, 49.
Yeah.
48 and 49 are with that.
Okay, so I think what we should do, I think we should have a brief break so people can get food. If you're still eating or whatever, when we resume, please feel free to turn off your camera, and that way we can sort of at least keep going. So I would say maybe 15 minutes, is that, or 10 minutes?
So 12:45.
Is
So
that
12:40 or 12:45?
I think we should do 12:40.
And then when we resume, we'll start at number 48.
Then we'll take 48 out of order, and then we'll probably just resume the order after that. And I think it would be nice to just be completely done, but that way we'll get to those important issues. Okay, so I'm actually just going to turn off my camera and mute myself and come back in 12 minutes. Hi. All right. We're back.
All right.
So, I hope people are at least listening in. So is it Patrick McGinnis who's presenting on 48 and through 50?
That's correct, Madam Chair. This is Patrick McGinnis.
Great. Okay, why don't you go ahead, and we're particularly interested to hear kind of the what have already been resolved, but of course we'll hear more from once you've presented on these. Go ahead.
Thank you, Madam Chair. So 48 through 50 discusses the uniform data collection, which includes the tracking of time, tracking information in a uniform manner, and establishing guidelines for the maximum caseload. Specifically, number 48 focuses on creating a workload. There's really two significant changes in section 48. The first one is that the workload study now requires one to be done in a population of less than 100,000 and one greater than 100,000. We felt that needed to be set aside, noting that the volume of cases in these jurisdictions is significantly different. If we tried to combine one study, we would not have accurate results. The other section that is important to point out is that we want to require the counties to participate in these workload studies. As the board is currently aware of, we are under contract with the National Centers for State Courts, and we are currently going through the process of a weighted caseload study. Our executive director has sent out letters to the variety of jurisdictions, the county managers, requesting that their attorneys and staff participate in the weighted caseload study. This is at the direction of the National Center for State Courts. If we do not have the participation of these individuals in this study, we're not going to have accurate results. So that's one really important area I think that we need to focus on. As you can see underneath NRS 18320, the board has to create maximum case loads. Additionally, underneath the Davis settlement, it's required, the Davis settlement requires a caseload study and or a Delphi study. So that's the two main focuses. I don't know if there's any comment on section 48. I think most people can agree that a workload needs to be done. I mean, through anecdotal evidence, talking to the attorneys in the rural counties, they feel very overworked.
Okay,
So I just wanted to follow up, because there was commentary from the institutional defenders on the workload study and its application to the urban counties. So has that been sort of addressed or resolved?
I think they wanted clarification as to who would be paying for the workload study. And I think we stated that the department shall conduct it. So that would be a state expense. I don't know if they would like to chime in. This number 48 wasn't really the focus of their concern yesterday.
Good. Go ahead, Ms. Thomas, or Mr. Scott, and then Ms. Thomas.
I'll defer to Ms. Thomas. She has her her camera on already.
Fine.
So this is Janelle. We touched on this yesterday, but probably more in the context of section 49. My immediate concern is that doing a workload study right now under pandemic conditions would be meaningless. We're not going out of state for investigations. We're not doing trials. Our in-town investigations have been greatly diminished. We're not doing contact visits with clients. So any results that would come out of a study right now would only be valid for other pandemics, which I'm hoping to avoid. We're concerned, I think we're all stretched pretty thin right now. It's hard to know, intrusion's a strong word. We're not opposed to doing this in theory, but it would be nice if we had some idea of the time estimate involved. and whether it would be done with a sampling of our offices, the offices as a whole. Right now, I think adding the burden wouldn't be justified given the invalidity of the data.
Go ahead, Ms. Reba.
Thank you, Ms. Thomas.
Goodness, yeah.
Yeah, this is Patrick McGinnis. You do have several concerns, and I guess the first one I'll address is the concern about having a Delphi study and or a weighted caseload study done during a pandemic. And we recognize the constraints placed on us because of the pandemic. We have consulted with the National Centers for State Courts. They indicated that despite the pandemic, that during the Delphi study is where the experts all gather at the end of the study, that we would be able to achieve an accurate case-weighted study based on the participation of the individuals in the Delphi study. We're not suggesting that we conduct one right now in Las Vegas and or in Clark County. First off, we don't have the funds for that. And second off, you are correct that it probably would be more accurate during a time when there is not a mass pandemic. The reason why we've got to go forward is also because we have money from the IFC and it expires in June if we do not use that money for this Delphi study. Now, regarding the questions about the specifics of the study, we would not be able to answer those questions until we entered into an RFP with a company who is going to do the weighted caseload study. Currently, the time frame that we're looking at for the rules is a 6-week time period. It's January 5th through March 25th. And we would like to have all individuals participate because then if we have everybody participate, that would give the accuracy that we need. If you have any other questions, please let me know.
And the beauty of the NCSC, just to add, is we did create an advisory committee made up of attorneys to try and determine what we needed to capture, how long the study needed to be taking place. So our goal would be within the next 5 years, once we complete our rural workload study, to do one for the urbans too at a time that's appropriate. But we want input from Washoe and Clark and their advisory committee as to how it should be done. But ultimately, the process by which it's done would depend upon who the state is able to contract with. And there's certain limitations that we have to issue an RFP and then ultimately go through the process of vetting the appropriate vendor. So we can't really, like Patrick said, we can't answer that question until we're able to issue that RFP.
So I'm just going to hear that as not happening immediately, maybe not even soon, and there would be, the urban counties would be involved in the creation of that and design of that study through some kind of committee that mirrors the committee process we're using now.
That is
So,
correct.
Okay.
And this is Jeff.
Go ahead.
I'm probably a little bit more aggressive in the language than Jonelle is in her case. I'd like to have paragraph B there for our study be expanded to say that once the rural study is completed, and then at the direction of the board, when they think it's ready to move forward, that we would be directing the executive director to go out and solicit an RFP. So that 3 things really are true. The Davis case is focusing on rurals, and we can continue to focus on rural by doing the A and under 100,000. And B, we can wait till we know we have the money, we know the pandemic is over, and then the board itself makes the decision to move forward for the larger counties.
This is Darren Emily with Clark County Public Defenders. I agree with both of those things. The other factor that would have to be taken into account is I'm assuming that to do the workload study, the case management system is going to have to be up and running. This goes along with Section 49. I'll talk about that later. But our current contract with Justware ends on June 30th. As part of that, we are no longer allowed, we don't have the ability with Justware to run any reports currently. Because we've used Justware for about 17 years, we input over 30,000 cases a year into that system. The migration is going to take at least 18 months. And so, along with Jeff's comment, I would like to see any case study after implemented after our case management system was up and running efficiently.
This is John Scott. I echo Jonelle, Jeff, and Darren's statements and comments.
Okay, good. Very useful. Mr. McGinnis, sounds like you have what you need in terms of those suggestions. We can move on to, sorry, is it 49? Yeah.
The next one is 48A.
Oh, my apologies.
This one, yeah, this is the legal server regulation.
Yeah.
And what the board is proposing is that we require counties with a population less than 100,000 to use this program, and counties with a population more than 100,000 to build this into their request if they're seeking reimbursement from us. So we've already presented at our last meeting. We had individuals from the administrative office of the court discuss the benefits of a uniform software system for reporting. We've pointed out some benefits such as requesting funds that can be done directly through the system to us, the timekeeping capabilities in the next statute of how we break up. This can easily be done. The survey distribution can easily be done through the software program. So we are requesting that this board require the use of that case management system in populations less than 100,000.
Comments on 48A?
This is Julie.
Go ahead.
So I thought the board had not yet decided we were looking at an opt-in process or an opt-in option for the specific program.
Ms. Rivett or Mr. McGinnis, do you want to address that?
We have proposed these regulations. Our department is proposing to add this regulation. So that's our proposal to the board, is to require the use of legal server in our temporary regulations.
So this is Jeff. In reviewing the statute, and maybe I'm wrong and Marcy can point me to it, I think this board and this department has the authority to request data collection and request data points. I'm not sure that we have the authority to tell counties what system they have to use to provide that data, those data points. And so there's a hint of almost the typical federal government sort of blackmail here in the bottom, where the federal government tries to tell states on things, well, I know we can't tell you to lower the speed limit to 55 or lower the blood alcohol to this, but we'll only give you transportation funds if you do it. And that's kind of what the last part of this is. They're not going to tell the big counties what systems they have to use. But if the big counties ever ask for money, then we have to use their system. I've never really liked those kind of provisions.
Ms. Fitzsimmons, go ahead.
I understand Jeff's comments, but having worked for far too long as a consultant for NDOT, I'll tell you, they get a lot of money and they make a lot of mistakes. So, you know, when the feds are funding, one of the reasons that they have all of the CFRs and all of the provisions is for uniformity, which is really what this board is looking for. I don't know, you know, I agree with you generally, but in this case, it just seems like if we're paying for it and we're doing all of this, I mean, the county should be able to do that much. They can use whatever system they want as long as they use our system. Is that what you're saying, Marcy, for all the reasons you've articulated? Because I think in response to Julie, the board has not made a decision. I agree with that. We've discussed it a lot, but this is your recommendation.
Recommendation is to require the counties with a population less than 100,000 to use the program, And that's based upon the fact that we have sufficient funds to be able to provide it to them for free. We have repeatedly asked for suggestions as to wording for this regulation, and we have never received any sort of input from any interested parties as to how this should be written. So ultimately, this is where we're at with the recommendation, and this is based upon our meeting last month with the Administrative Office of the Courts, where they described the struggle that they had for 14 years in trying to get together language and the importance of a data dictionary, and that it was a very complex process when they're not all on the same system. And then we had Mr. Popovich from the Administrative Office of the Courts explain that when the specialty courts required everyone to use a certain software program, they had valid information that they would be able to take to the legislature, and everyone was reporting in the same way. And they finally had good numbers in their opinion, which, you know, the other office that wasn't using that software program wasn't able to do. So I think that the Administrative Office of the Courts kind of gave reasoning as to why a uniform software program would be beneficial, especially with the recommendation of this board that they want independence from the judiciary. And if there's independent counsel, they could immediately access us through the software program. We can get those surveys out where they're immediately sent back to us. It has the benefit of the text messaging capabilities. So there's a lot of benefits to this program if the rurals are able to use it. As for the second sentence of the counties over 100,000, our understanding is that Clark and Washoe do not intend to use Legal Server. So I don't know how the board would like to proceed with the funding mechanism or not funding mechanism. But that's just our suggestion at this point.
So, Ann, let me throw this out. I don't want to make it look like we're trying to be intentionally difficult on this. We are faced with a problem. Our problem is, as Darren indicated, we've got hundreds of thousands of cases stuck in a system called Justware. Justware sold their whole company to somebody else who I forget what their name is, but their program is called eDefender. Justware has said that they will not support that system as of June 30th. Legal Server has indicated that it's going to take them 18 months, and they've never done anything this big based on what their conversations with are. So I'm going to guess it's probably going to take 2 years for them to be able to do a migration over to their system. That means we're going to be sitting there at a minimum with a 12-month to 18-month time frame where we have a system that is unsupported, and the risk to the county of having that collapse and having no system during that time period is too great of a risk to shift over to Legal Server at this point. By going to eDefender, they have agreed that they will maintain our Justware system during that migration process, even if it takes longer. We have requested from them to give us just a price on just to maintain the system so we could consider using to Legal Server. They have refused to give us that price. So the only way that we can guarantee and bridge the gap for that 18 months to 2 years is to join the eDefender system, because otherwise we have no way of protecting our data and having a case management system. And if we have no system for 2 years, you won't be getting any data at all from us about anything. And so we are literally just trapped in there. But back to your language of 49A, leave in sentence 1, strike out sentence 2. That's my suggestion for the language.
In 48A?
Yes, ma'am, in 48A. That way you still have the rurals under 100,000, and we have no sentence dealing with the over 100,000.
Okay, I may be mistaken. I mean, we may be receptive to that change, but I'm just curious. My understanding of sentence 2 is that it's only if the counties are seeking reimbursement would there be any expectation of Legal Server, and so that probably doesn't apply anyway. Is that correct?
Well, it probably doesn't apply, although I could see off in the future if our state ever decided to recognize the fact that all of indigent defense is actually a state responsibility and not a county responsibility, then someday They should pay for all of this. So
Okay, Ms. Reba, did you want to?
You know, I would point out that Washoe and Clark did report their fiscal year reporting for 18-19. They also told us what they expect for fiscal year 21. So we do have those numbers to build into our budget for the maximum contribution formula. We were intending to request funds on behalf of Washoe and Clark if that's what they would like us to do. And we do have a number related to that. And that's built into what we're trying to request.
Okay.
And I think that when this AB 81 was discussed in the legislature, there was always an intention to include Washoe and Clark. Pointing that out, though, I mean, obviously Washoe and Clark are the biggest budget requests that we have because they're the bigger counties. And, you know, I don't know. I guess it's up to the board whether or not they want to require the usage of legal server. So it's one uniform system. You know, again, talking to other counties or other states that do indigent defense, they wish they had one uniform system so they could get everything on the same page. And maybe this would encourage a change. We have the price point for legal server for Washoe and Clark. We know what it would cost. We could possibly build it into our budget in the future. But that's ultimately not my call.
This is
Chair
Chris. I have a question whenever.
Okay, we have a few comments, so I'm gonna take Mr. Mendiola and then Chris G and then Mr. Arascata.
Thank you, Chair Trump. Dave Mendiola. So, hey, Jeff, I've got a question. So I understood what you said, but what I would like clarification on is, could you start making the migration to legal server at the same time you continue to use the e-defense? Is that what it was? The other system that they want you to stick with? Can you continue to use that until which time legal server migrates the data and can prove that its efficacy?
So the answer, Dave, is we'd almost have to have two migrations to do that. Right. Because they're going to have to migrate from Justware to eDefender. That would take 18 months or so to do. And then if we were to go to legal server, you'd have to migrate then from eDefender into legal server. I don't think there is any way we could have two different software companies working at the same time on our current Justware system, both trying to migrate it out. I mean, because they'd both point fingers at each other and say they're screwing up each other's work to get the migration. So it would obviously have been simpler if Justware would have done what we were asking them to do, which was to give us a price to maintain current Justware. Then we arguably could have paid that fee at the same time as we were trying to migrate over, but they refused to do that. And so to us, the risk of having no case management system for a couple of years is a bigger risk than trying to have a uniform set of data by all using legal server. It's an unfortunate circumstance. And by the way, it's not just our public defender. Our district attorney's office has the exact same problem because they have a Justware system and we're faced with the same problem with them. But it's too big of, I think it's too big of a risk.
Yeah, we have the same problem with our DA's office because they have Justware as well. We don't have one in the public defender's office, so it would be easier for us. But I see the problem. I guess the only way I see that you could possibly do that and or Washoe County would be to do your migration with the current system, Justware to the other. And then once that's done, then begin another one with legal server, which I think would be a nightmare. But yeah, it's a tough one.
Okay, Chris G, I think you're next, and then Mr. Arascata.
Yeah, it's just more just trying to figure out the circumstances. So it sounds like because Justware is going out of business statewide, we have an opportunity, and I think the whole intent of some of this legislation was to be consistent, get everybody on the same page, same data, and so forth. But the issue is with Justware going out and then the lapse of time period for legal server to be able to take on the two larger counties is about a 2-year process. Is that what I'm kind of hearing?
Yes.
Well, Darren can correct me, but that's what I think the months have been given to us.
Okay. So
Okay.
the rurals can transfer or translate over to the one we've adopted, but because you're going to be without something, Washoe and Clark, in 2 years, no matter what, with Just Serve going away.
No.
So
that
is
is
there
not-
is that correct or no? Maybe not.
No, that is not correct. This is
Okay.
Darren Emily with Public Defender's Office. We would be without a system if we did not go with eDefender for at least the 18 months. And that's how long they've given us the migration would take from the start of it. If we go with eDefender, then we'll continue to receive updates with Justware, support through Justware. Then we'll be on the eDefender system, and we'd continue on the eDefender system from here on out. So we would continue with that case management system.
And the same thing,
go.
DAs then? Go ahead.
The DAs will also have to find a new case management system, but they're going to be in the same dilemma because Justware was bought out by Journal Technologies. Journal Technologies is the one that runs eDefender. And so the district attorney's office is going to have to decide, are they going to go with eProsecutor, which is the prosecutor product, or with Carpel or some other system. I do not believe Legal Server has a prosecutor case management system. And in Clark County, it's the Clark County Public Defender's Office, Special Public Defender's Office, and Office of Appointed Counsel. The three of us currently use Justware, and the three of us have, after all the demos by the different companies, have selected eDefender for multiple reasons. One of the biggest is we cannot, under any circumstance, go a year and a half, 2 years, or longer with no case management system whatsoever.
Mr. Aristana.
Go ahead.
Thank you. We too are a Justware office. We have been vetting programs, including Legal Server, and it appears that the choice we're going to be making is to, it's called Carpel Solutions and their Defender program. It is an open-ended program, so we'll be able to generate reports, which is for our next part of the discussion. But I'll just share with you the primary reason, one of the reasons we did this is that I called around to defenders' offices of similar size that had gone from Justware to Legal Server, gone from Justware to Carpel Solutions. And just to share an anecdote in a response, honestly, this is from a defender's office here on the West Coast, same size. If I had to do this over again, honestly, I do not think I would convert our data over. The data conversion with Legal Server from Justware just didn't work. And it actually created glitches in their Legal Server program. They stated if they had to do it all over again, they would have just started from fresh, case one, into their Legal Server program. We cannot do that. We have over a decade's worth of data from Justware that we need to convert over, and Carpel is able to do that for us. So that's the position that we are in. Justware's end of life is in June. We anticipate, because of the open-endedness of the program itself, we will be able to create and generate reports to the commission, but that's for our next discussion on sections 49 and 50.
Okay, so I guess in my mind, it sounds like either, and I know we've recommended we're going with Legal Server. I've been through too many legislative sessions, which we called the Wanderer, and it was people who would spend $1 gazillion to buy the best product, and usually they never worked out. So I think the issue still comes down to is which is the best way to get the correct, accurate information into whatever system we wind up with. And it sounds like Clark has decided to do differently than Washoe, but both can still communicate with Legal Server based on what information they require. Is that correct?
I think it's that if I'm hearing Mr. Arascata correctly, I think it's not that they would necessarily communicate with legal server, but that they could generate the data specs as but I think that's partly what we're getting to, if I'm not mistaken. So I just want to hear from Mr. Picker. Are you still there?
Yes, thank you.
Sure.
I was just going to add on to John's comment is that with the district attorney's office here in Washoe also choosing Carpel, I mean, that's the big part is that we have to communicate with them. That's how we get our discovery. That's how we get everything. So that was an overriding factor besides the fact that the program, you know, after demonstrating both legal server and e-defender and Carpel, it was the one that our staffs, all three of our staffs chose. So, and I don't want the point missed. We can provide data. It's that we looked at the data that's being asked for in 49, and we can't provide all that data. Those data points that are being requested there would take, well, in my office, they would probably take, you know, tens of hours, maybe hundreds of hours. In Darren's office, I'm sure it's thousands of hours, if it could even be done, because we don't track case data in the same way. And we don't track the motions that way. We don't track cases coming back from warrant. So the number of data points that are being requested in there, I don't think we'll ever be able to provide without having additional personnel on hand. And that's our main, you know, problem with the requirement. And then the final thing, I guess, is something that we discussed among the 4 institutional agencies was that we don't know where this data is going. What's it accomplishing? Because the idea of funding for DIDS is mainly to assist the rurals. We're not included in that. So our data is, other than, you know, being nice to have, we haven't been given a reason why we're providing it. So those were, you know, those are some additional objections that we had.
Okay, Mr. Mendiola, is your hand still up?
Yeah, and I was just going to make the comment that that in the end, it seems to me anyway that the goal is to get the data, and Mr. Picker's comments I think kind of helped me out a little bit there because. So I guess I got a couple questions. First of all, Marcy, are the data points that you are requesting, did that come from your group or did that come out of the settlement or the legislative council?
Can I just pause for a second? Are we moving on to 49 and because is that what we're getting into content wise?
Yeah, I don't know. I'm trying. I think that they're kind of, you know, enjoined.
Yeah.
Just because.
The only reason I ask is because 48 is kind of specific to legal server, and I think there's there's lots of commentary on 49 in terms of the data. But I guess my question, I'm curious at how people feel about the suggestion of maybe lopping off the bigger counties in 48A, or having some other language that kind of brackets that topic would be another alternative, you know, that kind of kicks the can down the road or makes the timing more flexible. I'm not sure what the proposals might be, but I guess my question maybe is to the office, Ms. Reba and Mr. McGinnis, whether you feel like you've gotten direction on 48A or feel like you have enough to, like, whether you're set on 48A, or do you feel like we should keep going to 49 now?
I think we could move on to 49. We have direction for our next proposal.
Okay, Ms. Fitzsimmons, you want to jump in? Oh, okay, I'm seeing Ms. Fitzsimmons and then Ms. Kavanaugh-Bill. Go ahead, Ms. Fitzsimmons.
Real quickly, we cannot risk Clark County losing data or being unsupported for any period of time. That I think that this should just apply to the rural counties. I think Jeff's suggestion that we leave in part 1 and take out part 2. I mean, I applaud Marcy and her colleagues, you know, taking all this on, but I think that it's going to be, I think once they take this on, if we make legal server mandatory for the rural counties, then if and when Clark and Washoe feel that they want to make a change, they can do it. But I think we're getting way beyond our lane here in starting to deal with those two urban counties and their caseloads. And Mark's question was why? I mean, I didn't hear an answer to that, because it's not going to, I mean, the caseload study, the Delphi study is not going to include, is it, Marcy? Is it going to include Clark and Washoe?
Weighted caseload study is not going to include Clark and Washoe. And generally, weighted caseload studies provide their own software for reporting. So it's either a paper reporting or a software that they provide for the length of the study. So they don't need to be on legal server for any sort of software or Delphi study.
So if you get legal server and the rurals report in on legal server for all of the purposes, that was an excellent presentation last time. Do you think that's enough for now and we don't have to get to Clark and Washoe yet, or maybe ever?
Yeah, I think that we agree with the points that are brought up by the board. So we will recommend that the second sentence be removed and to keep first.
Okay, Ms. Kavanaugh, Bill.
Yes. So I have a lot of concerns about that first sentence, because the last time we had a full kind of, are we going to take action on this or not? We had the option 2, the option with the financial incentive. And I know at least Ms. Hill, the public defender out here in Elko County, was adamant that, you know, their system they have set up is connected both through the DA's office, the court, and that making a mandatory requirement of legal server would be very complicated for them. And I think for the same, you know, just the statements made by, I think it was Darren and also Mr. Picker, you know, they're moving to a system that they've already approved and is going to work for them. I don't see why we're singling out the rurals and mandating things on them. I'm not sure about all of the rural counties, but I know that Elko in particular was very adamant that they did not want to have to be mandated. And that's why I thought the language of the option with the financial incentive was perfect. And I don't know if you have that in front of you. I have mine in front of me, but I just concerned because I know that there was, like I said, at least from Elko County, that they were vocal about it. They did written comments, and Ms. Hill even attended one of the meetings. And the fact that our agenda doesn't specifically notice that we were looking at this, I don't know that people were aware that the mandatory data system was going to be looked at again.
Are you talking about the agenda for today?
Yeah, I mean, it just generally says we're looking at the new regulations, and the most recent draft was sent out on November 23rd. But I would be concerned that we would get a lot of negative response from the rurals if they're required to transfer all of their information to the state, to a state mandated system, whereas Clark and Washoe aren't required to do that. And I think Ms. Hill talked about the staff complications, and I think they've just changed their system this summer. So this would require them to yet again migrate everything into a new system that it doesn't sound like it'll match up with the system they have with the DA's office in the court. So I think the important thing is that we get the data we need. And I know we're going to talk about that under 49, but if the counties can do that, then they can do it. But if they can't, then they go on the action plan. I forget what it's called right now, but anyway, they can be looked at and we can address it then. But I think they need the option.
Madam Chair, this is Chris. I think for clarity, I believe, Marcy, that we voted as a board and the direction was that the rurals had to do it, but maybe that was a couple of months ago. So I'm just trying to recall.
I'm not sure about that. I mean, I would also have to look. But I mean, part of the issue is that these are the regulations that were noticed and posted with this workshop in mind. And so I am sort of mindful that we heard from the urban counties on this, but didn't hear from anyone else as far as I know. I mean, I do think that like the board is recommending this requirement for pretty solid reasons, and I guess it's not that there could never be some kind of other option to work out in the future, and these might be temporary regulations, but I'm not sure that we have the justification for building in another option right now when the option for the requiring legal server is pretty strong and unobjected. I mean, it's sort of, no one's weighing against it. I'm
trying to remember back because I believe we're rehashing something we already agreed upon, whether maybe girls may not have been all in agreement on it, but it seemed to me that the issue was the server project would apply to the rural counties. And then this language came in kind of looping the urbans in, and I think they've articulated why they should not be in that loop, but that we should move forward still with the rural component. And now you're right, because it's noticed, it's publicly workshopped, and that language is what we're looking at. And I think trying to change it now, but maybe there might be more discussion here. I'm trying to find my notes myself, so I'll hush up.
Ms. Fitzsimmons, do you have another comment?
Yeah, it's just to that point. We've gone over this several times. It's funny right now, I'm missing Bob Kroll.
Yeah.
Because he chaired at least 2 meetings when we were all with our masks in that room. And, he everything was listened to. My recollection is that the ELCO, I think Julie Kavanaugh Bill articulated ELCO's complaints, so did the public defender, and that we decided to move on and said that we would be this would be an issue at the work session. That's my recollection. If it becomes an issue, we can go back, but I don't hear anything new. And the other thing I'd like, that wasn't articulated before, and the other thing is, my recollection is ELCO was looking at going to the software this summer when they already were aware that this was, I don't know if I'm correct, somebody correct me if I'm wrong, but they were going to go to another, they wanted something understandably that was, could sync with the courts and the DAs, but before they committed to the system they're doing, we were already talking about this mandatory use of legal server. So I think that's a very different position than Clark County and Washoe County are in, where basically they've been held hostage, right? I mean, their backs are against the wall. It's not like they just chose to go with something else. They don't have really any functional choice but to do what they're doing.
Okay, so go ahead.
Madam Chair, just for the record, we did not take a vote. We have discussed it several times, but there's not been a vote on it yet.
But just to respond to that, it was clearly stated that this would go, it would be a discussion when we discuss in the workshop, which is where we are now.
The public defender or the office is on the Matt. I'm not seeing your last name, so I don't have it at my fingertips, but are you there and can you weigh in?
Can you hear me?
Yes.
Yeah, so Stephanie Foster was actually supposed to be the attorney representing our office on this study. Something came up, she wasn't able to. So I'm not privy to all the information that was discussed at the last hearing or the previous hearings in terms of Kristen Hill's concerns. But in terms of the position that we somehow don't have a meaningful objection because the Clark County and Washoe County were held hostage is not really on point, in the sense that we have a software system, it's Justware, and we are being told by this provider that they're no longer going to be supporting it, and so that we have to go to a new system, which could either be their new system or several others. And it's my understanding that our office wants to be on the same system that the DA's office is migrating to and the courts are migrating to. So it's not necessarily because we chose to make a new system based on the fact that we were aware of this mandatory requirement. It's that we had no choice to go to a new system because our current system is no longer going to be supported by the provider.
Ms.
You
Reba?
know, Madam Chair, the only differences that we point out are, unlike Washoe and Clark, we will be providing the software program to all rural counties. The expected go live date is March or April. So prior to the no longer supported system of Justware, which I believe is July 1st, they will be provided with another system. We were also aware that Elko County was interested in being, interfaced with these other software programs. And I think Dave could probably answer this a little bit better since he worked in software, but we basically gave them the contact information for legal server to ask them about interfacing, how much it would cost to connect the programs, because legal server thought that it would be a possibility where they could report through the legal server system. And I don't know if any action was ever on that to explore that possibility.
Madam Chair.
Yes, please go ahead.
Dave Mendiola. Yeah, so I think that what happened with Elko is that they made a determination to have an integrated system. And again, that goes back to definitions, what that really means. And again, with some software background that I do have, that has a lot of meaning to it. Could mean a lot of different things. The point being, as far as I'm concerned, is I think the Elko ship has sailed. Forcing them to use legal server, I think, made a number of runs at them. I did through their county manager's office. And, in the end, that's the way they wanted to go. So I think going back to the earlier problem of going to 49 is that the bottom line is we want data, right, from the rurals. And so, in my opinion, it's incumbent upon Elko to provide the data that Marcy's teams needs. So, I think to fight this over here is a waste of our time. I think we need to come up with some either language or just realize they're going to be an outlier and they'll have to be dealt with, in terms of dealt with, they're just going to have to figure out some way to get the data to us. And it might take more work on their part, but it's my opinion that they've made a choice to go that direction, and I understand why. I don't have any problem with that. It's just that now we still need the data, and that's what we really ought to address, is how to get that data from them and require that they provide it, whatever it takes for them to do that. And again, the Clarkson Washoes, they're a totally different situation, and I think they ought to be. We shouldn't even be talking about them. This is a rural issue.
I guess I'm wondering on section 48A, if would be openness to creating something the way, I'm not sure if I have that sentence that we might have been drafted before, but something like the system, sort of case management system provided by the department at state expense, or provide data as required by section 49 to the department at county expense?
I think so. Something like that, yes.
Chair, the points that we would bring up over at our department are we are short-staffed, so we don't have the staffing to be able to put it into the legal server system as after it's provided to us in a different way. The survey system is required to be sent out, and one way that we could do that is to send it out through legal server, and it would automatically come back to us, so it would be able to meet that requirement in Davis. Any sort of notices that are required to be sent out to the rural counties could easily be put forth through the legal server program. And if all the rural programs are required to use legal server, we'd have up-to-date information as to what their caseloads were and whether or not they were complying with the weighted caseload standard, or if there are any sort of issues. If they aren't involved within our software program, we wouldn't have that information until a later date. So any action that our department could take would be delayed. And I think that this would go back to the issues that were pointed out by the AOC, that when everyone has their own systems, we're going to really need to have data dictionaries, specifically defining what certain things mean as we go through, so that everyone is basically entering the same data. And if we're able to require the same system, we have it built a way that everyone would be basically using the same sort of ideas when they're reporting. So it'd be apples to apples rather than kind of someone guessing and providing something else. So those were concerns, and the reason that we're really encouraging a uniform system is just based off of what we've learned in talking to the AOC is when they had a uniform system, they had valuable data that they've never really been able to experience before they went to this uniform software program. So that would be our recommendation. But if you'd like to change the language in some way, we'd just like to make the board mindful of our limitation on personnel and entering this information.
I guess my thinking on that was not necessarily to say that they just hand over the data, but that in some way they kind of bear the responsibility of those additional staffing costs. For example, if there's someone in their office whose job it would be to figure out that interface, or if it can be done through legal servers. So I feel like we should. I don't want to leave it prematurely, but I do feel pressure to go on to 49 because I do want to make sure that we're getting the comments on that, which is really important. So, and we've sort of migrated over there anyway. So, because our institutional defenders are going to be leaving, so I want to make sure that we cover that. Can we, Mr. McGinnis, can you sort of do your part on 49, and then that way we can hear from people?
Thank you, Madam Chair. I'm not certain if the institutionalized public defenders would like to make comment before, or if you'd like me to just to launch right into number 49.
That would be fine with me.
This is Darren Emily with Public Defender's Office in Clark County.
Go
I don't
ahead.
know if they're going to include any of the changes, Marcy, that we spoke about yesterday, if those would be included, because that would alleviate the need to comment further.
Oh, okay. Why don't we hear that? And that will give us more direction, and then.
Certainly. Thank you, Madam Chair. We had a very productive conversation yesterday with the institutionalized public defender's office, both from Clark and Washoe, and you've heard their concerns about their case management systems. One of the issues that we were dealing with was whether or not to exclude them completely from the data reporting requirement. But then we came to the conclusion that the best result would probably be is just to limit the amount of time. It's my understanding is to exclude them right now, but at some point in time to include them into the reporting and to give them opportunity to get their systems up and running. We don't know how long that's going to be. They're anticipating 18 months. So at this point in time, we are in agreement with the fact that they're unable to report based on how 49 reads, because they're changing to new systems. The systems they have now are coded to report a certain way. They can't recode the systems, report the way that we want them to. So right now, I think it would be nice just to carve them out of the data reporting requirement, but somehow we need to include them in there at some point in time.
So the recommendation would be on 49 to bring back the language of attorneys in counties whose population is less than 100,000, or to change it to that the this regulation is limited to counties whose population is less than 100,000, and we could later address this issue with counties whose population is over 100,000.
This is Darren. That would resolve the issues that I shared yesterday. So thank you.
This is John Arascata. I believe that would resolve our issues also. I would just though like to add, because that we'd like to be able to negotiate and discuss relevant data points when we get to that time frame, because quarterly reports from us, you're going to receive mishmashes of data because of the life of a case and how they overlap. And then also I hearken back to what Laura said earlier, that this is about the rurals, and the data from Clark and Washoe is going to skew the rural data, which is the subject of the settlement from the class action and the case itself, because we're 90% roughly of the criminal cases in Nevada are in Clark and Washoe. We're going to skew the data for the rural counties. So I'm happy with the, lack of better terms, kicking the can down the road for 18 months. But when we start to discuss it, I'd like to have good faith negotiations with the department regarding what are the relevant data points beyond our annual reports. and also that we not submit quarterly reports, that it be an annual report or maybe every 6 months.
And can I interrupt real quick? For clarification, it's not 18 months. The migration will take 18 months from the start point. And so I just don't want it to say 18 months because that's not going, we won't have the system up and running by that point.
And we'd like to remain uniform with Clark. So whatever that start point is, we'd like to be a part of that starting point also.
This is Jonelle. One other issue we discussed was the meaning of, in section D, the outcome of each case. I don't see a definition for that, and that would definitely be subject to interpretation. It would also arguably impose a huge burden on our staffs as to entering that kind of data. There's such a variety of factors that could mean. So we would ask ultimately to be able to discuss that element as well.
Are you working off of the LCB draft or the other subsequent draft?
I'm on the subsequent draft in section 49(1)D.
Got it. Okay.
Anne?
Madam Chair, you're on mute.
Go ahead, Mr. Wells, sorry.
So, well, Darren and Janelle had told me that the recommendation was going to be to limit this to the under 100,000. And obviously that solves Clark's and Washoe's immediate problem. But I would like, just for our friends in the rural counties, I actually think some of the points being raised in their correspondence has concern. The quarterly reporting arguably should either be semi-annual or annual. I would agree with that. Janelle just talked about the issue relative to the phrase of outcome of each case. I'm curious why we have H under paragraph 1, which is the total number of motions to suppress and the motions litigated. Maybe Legal Server tracks that. I'm relatively positive just where it does not track that one. Then when I move to paragraph 2, we jump, and I just want to jump all the way to the end for the moment. We have TPR cases and dependency cases and mental health cases and guardianship cases and all of those. And I've had prior discussions with Marcy about this, and I understand, I believe, why they want it. In many of the rural counties, the attorneys that do the public defender work are also assigned that group of cases. I'd like to lump R, S, T, and U there into a subset of an R and simply say, in cases where the county uses contracts that provides for these services, as well as the criminal cases, to provide that data. It makes no sense if the county doesn't have a contract doing that to force the person to produce all that data there. So we'd only capture those counties where the same contract has all of that information. And that's my only comments for that section.
So I have a question about the quarterly or the frequency of reporting. Much of this data I'm gathering, if the county is on Legal Server, there can be any number of reports kind of just run at any time to kind of figure out what's going on. So I'm wondering if then just having semi-annual or annual reporting is sufficient.
The quarterly reporting is directly from Davis. So if you'd like to change that wording, we could, but the quarterly reporting requirement is in Davis, and that's where we got that from. But you are correct, if individuals are using Legal Server, the information is immediate, so we're able to pull that at that immediate point in time. One point I'd like to make about what Jeff Wells said regarding the in subsection 2, the difference of the different types of cases and how he thinks that R, S, T, and U should be clumped together. On our advisory panel, we have several county managers, and they expressed a desire to know specifically what their attorneys were doing, and they stated that their attorneys are appointed in these cases. So they did request that these items be separated. Another item I'd point out is that there is possible federal grant 4E funding for representation of parents in 432B cases. So we're exploring trying to get those funds for the rural counties, but possibly.
Marcy, I apologize for interrupting. I did a really poor job of explaining what I recommended. Rather than say the words all 4 times, I meant there to be R1 would be 128, R2 would be 432, R3. You'd still have them separated. That way we only have the lead-in language once, and the lead-in language would be if a county uses a contract that requires these services for the public defender, then they report on these, and it would be 1, 2, 3, and 4. You'd still have those 4 data points separate, but all limited to county that uses that type of contract.
But during our conversations with the county management, including Dave Mendiola, he found that that would be important to capture even in an institutionalized public defender's office, which is also consistent with the data points that we are collecting during our case-weighted study, which is important because that's creating a workload. And so we're going to be able to extrapolate those numbers based on our study to track and make a determination if the attorneys are doing or are in compliance with the workload.
Sure, and as long as you have a county which is doing that and having the same public defender do those kind of cases, you could track that. But we have other counties where public defenders are just doing criminal cases, not doing any of these things, and so that's the point I'm trying to get. When you have the person doing both kinds of cases, then we'll track it. So you can show the workload and that, and when they're not, it's not an automatic requirement, is because it's not a useful data point when they're not both doing it.
Okay, Ms. Fitzsimmons, do you have your hand up?
No.
Okay, thanks. Other comments on 49? Sounds like if.
Yeah. This is Chris. Just at some point, are we going to talk about, I know it was in Jonelle's recommendation, but kind of putting things together when the reg comes forward, separating what's pertinent only to 100,000 and under and what's pertinent to everything else, so that it's easier for guidance for review. Is that something that was discussed or is going to be brought back up again?
Ms. Reba, do you want to comment on that? You probably have the best viewpoint.
I think that we try to clarify whether it applies to each county by the language of counties with a population less than 100,000 versus counties with a population over 100,000. The only counties with a population over 100,000 are Clark and Washoe. So that's how we were distinguishing between the two, because that's consistent with the statute of NRS 180. So that's why we carried that throughout, unless the board would like it to be written in a different way.
Yeah, 180 is kind of choppy. A lot of them are. It just sometimes it's like, okay, all of this X, Y, Z pertains to under 100,000. It just is easier for people who want to read it, research, or know what they're going to be held accountable for. But I don't want to make more work for the staff. Part of it is because the statute is badly drafted in the first place. And then I had a second question. You did a business impact statement, and I don't believe in reading through it that there were objections to what's now being objected to. So did I miss that in any of the discussion?
Go ahead, Ms. Freeman.
There were the objections that were received were placed in there about the data collection, about the increased work that the independent contractors felt would place on them, but we feel that providing legal server to all of those individuals, we did state in that business impact statement that that's where our recommendation of requiring legal server is coming from, because it would assist the small businesses in being able to comply with this data collection. And our recommendations were noticed on the agenda, as well as attachments of our recommendations were provided on the website. So I believe that there was sufficient notice of these recommendations from our department.
Okay. And then just finally to wrap it up, Madam Chair, then I would say in your business impact, you also had a budgetary impact, 5 million something and 6 million something. If for some reason this change is that it's legal servers not required for the purposes, that's going to have an impact on your department. So I think you need to make sure that your dollar amount is modified to reflect that.
Thank you. I would agree with that. We would likely need to increase our staff for data collection to be able to process the information.
Correct. Thank you.
Okay, I think we are done with 49. Sounds like the concerns were addressed there. So I guess the question is, we sort of are not completely done with 48A, perhaps, but we're about to lose our institutional defenders. I'm concerned about that. I'm not sure we have time to address anything else meaningfully, but Ms. Reba, anything in particular you feel like we should be doing before they leave us?
The only thing is in 50, we did do a carve out for counties whose population is more than 100,000 to require timekeeping only when a weighted caseload study was taking place. Other than that, we do not have any sort of timekeeping requirement for counties whose population is more than 100,000. So I do not think we need them for section 50.
Okay. Okay. Ms. Thomas, go ahead.
I just wanted to say thank you for listening to our concerns, and I know collectively we're sorry that we have to leave, and wish you all well. If there's any information you need from the four of us, definitely let us know, and we look forward to working with you all.
Yeah, thanks for spending so much time with us yesterday. Thank you very much. Appreciate that.
Well, I just want to say we really appreciate the very detailed comments, which are not only useful for securing and letting us know what you need, but also sort of overall for defenders. There's a making us more aware of issues. So we really appreciate the time and meeting yesterday as well as attending today. And thank you so much. We really appreciate it.
John or Scott, I just want to say thank you also. And believe it or not, it's been a long process, but I've enjoyed it. It was interesting. Thank you.
All right, thanks. So do we feel like before we are done with 48A, we should, I mean, are we done with 49 and 50 and should we circle back to 48A or just with anything specific?
If you want to finish 50, it'd be pretty quick.
Let's do that.
Thank you. As Marcy was pointing out, the subsection 2 is for a population of 100,000. Just keep time during the weighted caseload study. The section 1 is for the population of 100,000 or less, and it mirrors the recommendations of Davis on page 18 on what that needs to be tracked for time and reporting requirement. So we'd ask that that be adopted.
Okay, any comments on 50? Judge Flegelmilch, you have your hand up?
I do.
Okay, go ahead.
All right, so I guess I have a question in relation to this. Is this for, all right, so in relation to the hours provided per case, is this for just the contracted indigent defense providers, or is this for an appointed counsel on a conflict, or what? I guess the question is that there seems to be some disconnect here on how many attorneys are even available in rural Nevada in order to provide any services. So it's, you know, so the question is, a lot of the conflict attorneys who will come in on a case here and there have indicated their dismay at the fact that they're going to have to keep all these required whatchamacallits, because they're not a quote unquote a provider of indigent defense services. They're just the singular attorney who comes in on a case because the 3 public defenders in Lyon County have a conflict. So, and I wouldn't imagine that Marcy's going to give him a brand new case management system for their offices when they take one case maybe a year because of a conflict. So I guess the issue that we seem to be having here, especially from what I understand in our municipal court, is here in Yerington specifically, their inability to find any attorneys already without any such requirements to take cases, let alone attorneys who are currently taking cases saying if they have to do all this stuff, why even bother taking a case? They'll lose more money than not. So I guess that's the question. I mean, if you have a contracted public defender, I mean, you can negotiate any requirements you want, but if you just have an appointed attorney who does a singular case or maybe a 4 or 5 cases a year to do all this stuff, I think I want to know where the attorneys you're going to find, these attorneys who are willing to to comply with those requirements. So I guess that's a question. Does it apply to just the contracted attorneys providing quote unquote indigent defense services, or does it apply to appointed counsel who do a few cases here and there?
Ms. Reba or Mr. McGinnis, do you want to?
I can answer that. I believe that this applies to all providers of indigent defense services under NRS 180.004. So those appointed counsel would be required to submit their time. We will be providing conflict attorneys with a limited legal server ability. So it'd give them the ability to enter their case and to say the time that they did it and keep time tracking consistent with Section 49. They just wouldn't have the full access that the institutional offices would have to be able to keep, a large amount of cases in there and such. So it would be a limited access case for purposes of reporting will be provided to them.
This is Chris. I think it might be helpful for folks to remember that this is all due to a settlement of a case and that there's certain language that we have to have. And I believe this is one of them that's under that.
Yes. Ms. Reba, did you want to say anything else more about sort of timekeeping generally, or what's
that? Exactly what Chris G said. This is required. We did make one modification because Davis required the time tracking for attorney and staff. We didn't feel it necessary to require staff to keep track of their time. So we're not recommending that because I don't think that it's beneficial for offices as a full to be able to keep track of that. We don't have any sort of workload, basis for a staff member to require them to report. So we felt that to limit it to the attorneys, investigators, and experts would be sufficient.
Okay. Ms. Forsman, I see you have your hand up. Go ahead. Franny Forsman, are you there? Possibly unmute. I can't see you. So.
Okay, can you hear me now? Okay.
Yes.
So I think that because that diverges from the language of the settlement, that the department should go to Craig Newby and discuss that with him. I'm not suggesting that there'll be huge opposition to it. I'm just saying that probably needs to be done because the monitor is going to have to go in and measure compliance.
I agree with Franny.
Okay.
Add back attorney and staff? Or would you rather us request to remove staff by Mr. Newby?
No, I agree.
Oh, I'm sorry. Go ahead, Jeff.
I was just going to say, I agree with you that we should go to Craig and let Craig discuss that with council.
I'm not sure the board has a viewpoint on either way, and I think it's something to just ask and figure out. It seems like it might be time saving not to track staff, but it would be not time saving if it violates the settlement agreement.
Well, I apologize for jumping in. I actually agree with Marcy's proposal. I think it's not productive to track the staff time, but I agree with Franny because it was part of Davis. I don't think we should just blindly do it. I think we should go to Craig and let Craig go to their council and discuss it in that fashion.
And I think because of my position as counsel in that case, I'm not going to express an opinion on it.
Good idea. Okay, go ahead.
Dave Mediola, I was just going to say that I think that proposal kind of applies to all these things we're talking about where we have outliers. If we don't have counties that can meet the criteria for whatever reason, those are going to have to be cutouts in my mind. So I think they all apply.
You mean they all apply to the problem of whether they can be, sort of not governed by the lawsuit? Is that?
Yeah, that's what I'm saying is that if we have, for example, Elko County example with respect to legal server. So if they won't, and we can't get the kind of reporting material or information we need from them, that may be something that we have to discuss with council as well to find out whether they'll allow that to be some kind of a carve out, I guess is what I'm saying. Or maybe it has no bearing. I'm just thinking it, because every time we're talking about one of these things that sits outside of the regulations we're trying to set, that comes out of Davis, seems to me, those are the kind of things we kind of had to hand off to council and say, hey, can you help us with their council and figure out whether we can work around this?
Okay. So any more comments on 50? Should we return briefly to 48A, or is that Ms. Riva and Mr. McGinnis? Do you feel like we need to return to 48A?
I don't know what the board's guidance is as to where they would like to go. It seems like there's two different recommendations. It seems like everyone agrees to remove the second sentence of requiring Clark and Washoe to use it, but it seems some are in support of keeping the first sentence as is, and others believe that we should create a carve out that if they're able to provide data, it would be done at county expense.
I guess one response to that is, go ahead.
Oh, sorry about this. This is Rob Sayas. I do tend to agree with what was said earlier about the fact that, if you don't present it on the same platform, it's going to be so much harder to really analyze worthwhile data, especially if other systems don't quite aggregate the data the way that legal server would. I just think it's going to be a total mess if folks don't use all the same system. So I would support, leaving that sentence as it is.
This is Chris. I'm inclined with that as well. I've been trying to go back through the minutes, and I apologize. I thought I filed them someplace to see if it was reflected, because we've had this entire same conversation before. And I think I apologize. I'm getting old, so I can't remember if it was the incentive was the county then picks up the cost, but you still have to give them exactly the same information that you're asking for. If that's where we landed, I agree with keeping Clark and Washoe out. It's not necessary at this time. But it's in lieu of staff remembering or anybody finding the minutes on that, I thought we concluded one or the other. And I apologize because I cannot find it in the minutes.
And Chris G, my recollection of what occurred is we did discuss it and we weren't able to agree. So Chairman Kroll did ask for input of alternate language, and we took this matter up at the next meeting. We informed the board that we had not received any sort of alternate language proposing anything else. And then we scheduled the meeting with Legal Server last month so that the board could learn the benefits of Legal Server, and with AOC to learn the benefits of a uniform software system. So I don't think it's ever necessarily been agreed. This is the proposal that the board is, or the department is making to the board to accept and move forward for the purposes of our public hearing. So that would be our request, is to have it be a requirement.
I want to ask.
Let me finalize that with Franny still in the room. With the intent of Davis, in your mind, is it adequate that as long as we get exactly the information that's asked for, but not making our staff have to do more work or pay for it or anything along those lines, would that be in compliance, or does that just get us back into a whole nother problem again?
Gosh, I'm afraid I feel sort of uncomfortable expressing an opinion on that, because because if we end up in a conflict on it, I don't want to be binding my co-counsel and clients. So sorry.
That's why you're attorney, so I totally get that. So I will withdraw that question.
Okay.
So I have a process question. So one option, obviously, is we have not actually been during this meeting asking the board to sort of ratify a any particular thing. So I'm mindful of that, one. And I also wanted to ask Ms. Riva and maybe Ms. Long, the next step, what's happening on January 28th? Because one option is to kind of leave it as is, but with a little bit more wiggle room to see if something could be worked out. I just wanted to ask that process question so that we all understand that. After today, what happens on January 28th, like at the next meeting?
Sorry, this is Sophia. Do you want me to answer that, Marcy, or?
Yes, please.
Okay. So after the workshop today, if you pretty much have direction, given to your executive director, she's just going to clean it up, and it should be a public hearing where you pretty much just adopt your regs.
Okay. And if we were to make subsequent changes after today that, like to this provision, for example, would we have to notice that up again, or could we just sort of post that as the final?
We can post it again because at the next step, you're still taking comment.
Okay. Okay. So one option then it would be to sort of leave it as is with the caveat that there might be an opportunity to kind of work out some language. I would say my own opinion is I do think that there's a strong argument that, like, without Legal Server, it's just going to be a huge workaround to get you something less than what Legal Server would deliver. I think that's probably a reality. But at the other, and I think the sort of way to, if we were to accept that there was some other option, which I don't think we need to do, but if we were, then I think the burden has to be on the county to really shoulder that burden completely, perhaps, so that it doesn't shift to the department, but as a practical matter. But so one option is to leave it as is and think more about it and kind of move on. How do people feel about that?
This is Chris. I would tend to agree with you. We've beaten it up twice. I think leave it as it is with the exception of removing the second sentence. That's how it comes back in draft form. And we agree to discuss it one more time. I think there were a couple other sections that needed to be fixed or clarified as well.
So what I think we maybe should move forward with that. And then with I think that part of it is, it would really be nice to hear from Elko County and Legal Server maybe one more time what is feasible and what it would return in terms of the data collection, because we want to get that right. I don't think we want to put up unnecessary barriers to Elko County, but I think we want to be realistic about what exactly would be the process and the result.
Madam Chair?
Yes, go ahead.
This is Julie Kavanaugh Bill. So would it be possible too, when we discuss it again, that we have both of those options? Because the language you were talking about before we moved on to 49 et al. Was kind of the same language. It's an option too. It might be useful to board members to have it in front of them.
I would favor that we leave open the possibility of some workaround that gets the department where it needs to be without additional expense and gets Elko to sort of deliver that. And I think that that's language that could be considered. Not that it would necessarily prevail at the end of the day, but that we just use this time to kind of work that out and try to get something that really would be an ideal situation for all involved.
Okay, thank you.
Okay, with that, I think we should move on. I appreciate everyone's patience and go back to 27 through 39. And is that okay? And then I think Mr. Hickman, are you handling that section?
Yes, Madam Chair, thank you. So the next section deals with the qualification, the specific attorney qualifications and the qualification process. Just as a general note, the idea or the concept of the qualifications comes from NRS 18320 2D1, and just quickly how that reads is, in addition to the duties set forth in subsection 1, the board shall adopt regulations establishing standards for the provision of indigent defense services, including without limitation establishing requirements for specific continuing education and experience for attorneys who provide indigent defense services. So the qualifications with relation to specific experience come from that particular section. In terms of the department's proposals, just kind of quickly, what came back from the Legislative Counsel Bureau in sections 27, 28, and 29, there is no proposed change.
Good.
With respect to section 30, this is one of the provisions that we are proposing be removed in its entirety. And the reason for that is essentially it is redundant when compared with other sections. What we're really after in this section is the first paragraph, that the ability, training, and experience of an attorney in a criminal matter must match the complexity of the case. That has been relocated to the next section, 31. Paragraph 2 is redundant because sections 31, 39, 49, and 50 provide requirements for qualifications, training, education, and data collection. And then paragraph 3 is redundant because sections 31 and 40 provide consequences for failing to apply and not practicing within those qualifications. So the recommendation at this point is just to remove that section in its entirety. Moving to 31, this is the, again, we've talked earlier about the department roster or list of eligible qualified indigent defense providers that's found in NRS 180.430. And so this is the application process for becoming a part of that roster or list. Modification to paragraph 1 again wraps in that general standard that we pulled out of the prior section. In paragraph 4, there are some deleted materials there just to kind of clear up and get rid of excess language. The addition in paragraph 4 provides a very flexible process for increasing qualifications as time goes on and experience is gained. Paragraph 5 is the procedure for disputing or disagreement with respect to a department determination on qualifications. And then finally, paragraph 6 is that consequence we talked about in section 30 for not providing the application or failing to practice within the area of qualification. Moving on to the next section, if there's no comment, section 32. Again, that's proposed that we remove. Again, it's been wrapped up into that one procedure, section 31. So it's still there, just in a different location where it makes sense. The following sections, I guess, at least initially make sense to talk about as a whole. So I'm referring to sections 33, 34, 35, 36, 37, and 38. And those are the specific experience requirements with respect to different categories of cases. A lot of the concern that we received in reaching out to interested parties as this process has gone on is, essentially, where do these come from? Or are they just made up? Did they come out of air? How did you arrive at these places? And in kind of going through, the process for reaching these qualifications, I think we've provided some answers. So I think it's useful to go over those, with the board and, members of the public that are present. The starting point for each qualification was essentially Supreme Court Rules 250 requirement for capital litigators, and that was kind of treated as the maximum or the cap, right? Obviously, we didn't want to go any higher for lesser types of offenses. And then the next step was to review the same specific experience requirements that are contained within the Clark County model plan and then the Washoe County model plan, and kind of use those as a starting point for the different areas of qualification. And so with that, with Judge Schlegelmilch's previous concern about the availability of counsel, we tried to work backwards from that point in reaching those specific recommendations. And then we also considered there are a couple of areas in ADKT 411, the attorney performance standards that make specific experience requirements, and we also considered those. So those are essentially how we arrived at those particular requirements. In terms of talking about them all as a whole, I think that makes sense. If there's specific comment on each section, I think it would be easy just to ask if there is a comment to identify which section, and we can work that way.
Okay. Comments on these qualifications for these different subsections on qualifications?
And this is Jeff again.
Go ahead.
Section 31 says it applies to attorneys who provide the services in counties under 100,000. Then when I get to 33, 34, 35, etc., it all says pursuant to section 31. So I'm assuming all of those also are triggered to be under the 100,000 since they refer back to 31, but I'm just asking for clarification if that is correct.
Thank you, Mr. Wells. That is correct. Again, as I referenced, the Clark County and the Washoe County model plans already incorporate the specific experience requirements, and those have already been approved by the Nevada Supreme Court. The intent is not to do anything with or override those.
I did notice you borrowed some of it. I appreciate it. Thank you.
Any other comments? Okay. You want to move on?
I think the last section in this chunk is 39, dealing with the specific CLE requirements that arose out of that same statutory provision. Section 1, there's no change. That's generally kind of the guidance as to what CLE or educational requirements should reflect. We are proposing to remove subsection 2. The requirement that the department develop and provide CLE and training programs is in the statute and was pretty clear, so we didn't feel that it needed any additional explanation. Subsection 2, there are some deletions to kind of clear up language and remove a reference to a section that had been removed or proposed to be removed. But we did add subsection D because to provide, I guess, kind of, benefit to doing CLE through the department. There doesn't need to be submission of proof if the provider is doing the CLE through the department. We're already going to have that record. So that's the inclusion of that. This was also subject to the Clark and Washoe public defender office's comment as to whether or not it applies to them, and they have all their offices have developed training programs already that they offer to not only I think their employees, but also in some instances providers in rural counties as well. And I think their position was, given the development of their training program at this point, and the fact that it's provided to their attorneys, that this should also be included with the under 100,000 reference to Section 31. And in speaking about that internally, I think that is a good recommendation to make, and where we kind of landed in the conversation yesterday. So that would be the only additional change to 239.
So I think what I just heard is you are going to add the reference back to 31 for the under 100,000 for this.
That's correct.
Thank you.
All right, any other comments? 39?
Just a question, Madam Chair.
Yes, who is this?
This is Bevan Lister, sorry.
Just go ahead.
So being the dummy on the block and not understanding anything, did I understand the last conversation that the qualifications listed in Section 39 don't apply to Clark or Washoe counties?
So these are the annual CLE requirements, and yes, and the reason for that again is that those offices in those counties have developed internal training programs where they regularly provide their CLE to not only their employees, but often attorneys in other jurisdictions as well. So with respect to any requirements on CLEs or training programs, I think it made sense to try to direct that to where those services aren't provided by an office rather than where they already are.
So a follow-up, Madam Chair.
Yes, please go ahead.
So the CLEs are not credited to the individual attorneys, and a record is kept of that. I guess I'm missing something in the process here.
Mr. Lister, this is Jeff again from Clark County. The Supreme Court requires all attorneys to have X amount of CLEs, and so each of them have to individually, as licensees, do it. We in Clark County require this for our own contract for the independent contractors, and I believe what Jared's talking about is we also provide the CLE services in classes, not only for our own attorneys, but for the outside counsel as well. But there's provisions, for example, in 39, that would require each one of our 400 lawyers down here to have to submit their CLE requirements to the department each year and all that. It's an unnecessary requirement because A, it's required here, and B, they already do it with the Supreme Court. So I believe that's why they agreed to our institutional guys' request to take this out for the over 100,000.
That's accurate. Thank you.
Thank you. That helps.
Mr. Christensen, did you want to add something or?
Thank you, Chair. I was going to say the same thing Jeff just said. There's already requirements down here in Clark County to accommodate that.
Okay, good. Okay, any additional
Madam Chair,
comments?
I apologize. This is Sophia Long, your DAG.
Go ahead.
I have another meeting I have to jump onto real quick. So I'm going to leave and I'll be gone maybe about an hour. And if your meeting's still going, I'll be back.
Okay. Thank you very much. Can we move on to the next section? The next chunk, which is
Sophia, are you still there? So, oh, she left. I'll call her. I just want to clarify if we have to make any sort of motion or next step. So I'll call her. But we're okay to move on to 40.
Yes. Okay. So let's move on to 40. Is that Mr. McGinnis?
That is, Madam Chair. Thank you.
Go ahead.
Thank you, Madam Chair. Number 40 has to do with review, audit, and investigation. As the board's aware, we have a duty to review how indigent defense services are provided throughout the state. And the statute provides that, but it does not provide any guidance. In fact, it provides very little guidance on how that review process should be done. So Section 40 specifically deals with that review process. It's a relatively almost all new section. It was not submitted to the LCD prior. It's something that we developed after consulting with multiple indigent defense commissions, looking at their regulations, looking at their policies, and this was drafted based on that research. So if they have any specific questions, I can certainly answer those questions, but it's in essence just a process for the review of indigent defense services.
And I had a question, this Section 40 was flagged by the institutional defenders, so I was just wondering if that's something that was worked out.
It wasn't. We didn't discuss it yesterday. I can tell you that their concerns was whether Section 40 applies to a population over 100,000. And I can tell you that the subsection 2 pursuant to NRS 18440 does apply because it specifically states that review of indigent services throughout the state. So the subsection 2 certainly applies. So does subsection 3 because there's no carve out in subsection 3. The only area that may not apply would be subsection 2, section 2, subsection 2, where it indicates that the one deputy reports to the other deputy if a person is providing indigent defense services in an ineffective or otherwise inappropriate manner. So our thought pattern is that if the person who is monitoring and reviewing throughout the state has to report to the other deputy director who is underneath the 18430 if an individual is providing indigent services in an ineffective or otherwise inappropriate manner, that deputy underneath 18430 has oversight over the population that's less than 100,000. So our assumption based on our analysis of the statute is that that's the only carve out for the under 100,000 is if a person is providing indigent services in an ineffective, otherwise inappropriate manner, which goes back to the individual who is the deputy underneath 18430, works with the counties for best practices and training.
Okay. Any comments on that?
Nope.
Okay. Here, there's Judge. So let me see.
Yep, I had my hand up.
Yes, go ahead, Judge, and then I'll get Mr. Lister also had a comment after. Okay, go ahead, Judge.
Okay, so, and I just want to bring up just a couple of points in relation to the entirety of these sections that have just been gone over. So, in relation to you know, the requirements that are being set forth. And I think I've expressed this before to this board. It's going to be almost impossible to, and I shouldn't say almost impossible, but it's going to be darn difficult to have attorneys to comply with all these things that are on the list that are approved by the board or by the director or through the processes to come out to Austin, Eureka, you name it, Biawawi. We can't even get attorneys with some of these requirements here in Lyon County, which is the third largest county in the state of Nevada. So, and I guess the secondary issue on that is what happens, and this is going to be, I think, an issue for this board that you're going to have to address at some point. What happens when nobody applies? Because honestly, that's what I'm getting from at least the private bar. I mean, the public defenders on contract, I mean, they'll certainly, go through the process. But what happens when nobody applies? Because I don't see anybody from Las Vegas wanting to go to Eureka. And I don't necessarily see anybody from Reno wanting to go to Biawawi. So there might be some Vegas attorneys who'd be more than happy to go to Pahrump, but probably unwilling to go to Tonopah. So I guess in relation to all these things, if you overregulate the bar, because the bar itself, I mean, basically what you're doing is saying that it's not good enough to be a lawyer in the state of Nevada. You can, if you have the money, go to any lawyer in the state of Nevada that you want to, whether or not that person has ever been in a criminal courtroom, and hire that person, okay, for money to go into the courtroom with you and provide you criminal defense work. But if you're indigent, you need to comply with all these requirements because the courts themselves can't prohibit an attorney that's licensed to practice law in the state of Nevada to practice in their court. The State Bar of Nevada, the laws in relation to attorneys prohibit that. So are you not intruding into the state bar's purview in relation to regulating the practice of law? And then you're certifying attorneys for indigent defense when Nevada has a no certification provision in their rules of professional conduct. So unless they're certified by the bar itself. So there's a load of issues in relation to the requirements that are being set forth here that go well beyond, I think, and I think what you're going to do, because like I continue to tell you folks, we have problems finding attorneys to come in and do cases anyway, let alone putting them through all these regulatory requirements. I mean, I suppose if the ultimate goal is to consolidate everything, because that's what it looks like to me, honestly. If the ultimate goal is to consolidate everything into one singular state system that didn't work in the past and is unlikely to work in the future because there's no standards for the state public defender to come in. There's no regulatory standards that you guys have provided that if the state public defender comes in and takes over public defense, there's no requirement there at all that they even maintain an office in the county. There's no in the county that they come in for. There's no requirements in there in relation to what they do or what they don't have to do in relation to their provision of their service to the county, even if the county opts out. You see, this is a problem. Even if the county opts out and says, all right, state, take over public defense. Okay. So that doesn't mean that they're going to run the show from Carson City. If they, they're not required to have any presence in the county, none. And the fact of the matter is, what these regulations are doing, because they're so excessive of the state bar's regulations, they are driving attorneys from doing public defense as basically, because most of the attorneys that I know of in this county that does it more of as a public service than they do it as a way to make money, because they make money on their private cases when they don't make money generally on their appointed cases. So it's just a comment in relation to, and I think the ultimate question is going to happen is, what's going to happen when nobody applies to the department to be provider of indigent services because they're unwilling to comply with the regulations, because in private practice they can take $500, walk into court and represent somebody, and according to this it would cost them that plus all this extra time and money in reporting requirements, staffing, et cetera, et cetera. So that's my overall comment on all of these regulations that were just discussed, because I think you're really going to have a problem. I really do. Because the attorneys that practice privately, especially in my county, they make a lot of money. And there is no reason for them to take a public defense case, honestly. And we're not bringing in people from Carson City. I mean, even Douglas County, and let alone Humboldt County, or go to Battle Mountain, where maybe they have one attorney. Go to White Pine. Yes, I'm sorry.
Thank you. We hear you. I think that one of the things you're saying is sort of a broader mission comment, and perhaps less attuned to the specifics of this section. And I mean, we understand your comment. So I'm going to cut you off there so we can refocus on just the language of the sections. So I'm not sure that I'm hearing a specific thing as to section 40, and I'm just wanting to sort of hear if anyone else does, because then we'll continue on.
Madam Chair, it's Bevan Lister.
Go ahead.
Just to follow up on that, is that the more regulation, the more requirement there are on these public defenders, the more it's going to cost us as counties to try to contract and hire with them.
So I understand that comment. The sort of the mission at hand, right, is to sort of provide and regulate public defense, and also to alleviate and take that expense off the shoulders of the counties, so that the state is actually fulfilling its mission to bear responsibility for providing quality defense. And obviously the whole mission, like, we're not regulating people's right to hire counsel. For those people who have, that's just a different kettle of fish altogether, is the right to retain your own counsel, which is, this doesn't apply to. So yeah, so I think we understand those sort of global comments, but I think that these standards are sort of replicating what is considered the standard for quality defense in the state, and practiced by the urban counties, and sort of consistent with the ABA requirements and also the lawsuit. And so it's sort of covering multiple grounds at the same time. So we understand there's a problem if nobody wants to do this work, but I think right now the mission is to sort of describe what is the sort of standard for adequate, effective work that meets the constitutional standards.
Madam Chair, this is Chris. I think you summed that. Yeah, I think you summed that up quite well, and I appreciate and have a great deal of respect for the concerns that are out there. But our mission is, we're here because of a lawsuit, because indigent services were not being provided, and it's either this or we don't comply to the best intent that we can to make sure that we're providing justice for individuals, or the Davis case gets reactivated and the rurals will be on the hook for far more than what's occurring within these regulations. So I think we're trying to be as fair and balanced as we can, but it's been an ongoing issue. If anybody wants to go back and research the issue of indigent defense in Nevada, there's been commissions and case studies and rural committees and judicial committees for the last 25 years. And I think everybody is quite eloquent in pointing out the concerns, but I think right now the regulation in front of us is trying to be fair and balanced and just to try to move us along. I don't think that there's any objection if we could continue to move forward. We're close to getting done, and we'll just note in a minute the concerns that people have.
And I think I would also, I agree with that. And I would also say that this is one piece of a larger effort, which is very complex, right? So I think that's one reason to sort of keep our eyes on the ball in terms of what it is that's the standard that's trying, and in terms of attorneys. But obviously, shifting the burden of expense, this is part of sort of changing the culture slowly to kind of move the needle on indigent defense as well. That's a slower and bigger process. Of course, there are budgetary challenges ahead. We all know that. So I think just keeping focus on these standards and is really helpful, and recognizing there's lots of other challenges that we're keeping at bay for the moment, and we'll work through over time, hopefully. Okay, with that, can we move on to 42 and 43? Is that Mr. McGinnis?
Apologize, Madam Chair. We didn't know that we were on mute. We're going to request that we strike section 41. It's now contained in 26A. And we can move to 42 through 43 now. 42 through 43 are the economic disincentives and the contractual terms. Specifically, number 42 deals with the attorney's compensation. We added the word county in the proposed changes. Basically, we're looking at pay parity here. If you live in a similar area, you should be paid with a similar wage. We were going to request that 2, 3, 4 be stricken, as they will be discussed in 42A underneath the contractual provisions. So if there's no discussion that needs to be had on 42, we can move to 43.
42A.
42A, I apologize.
Go ahead.
So 42A is the contract terms that are going to be required for a contract when a county contracts for the Indigent Defense Services. We felt that this was important to carve out of section 42 and have its own section, because these are the requirements that are built inherently into the statute and into Davis. These are the requirements that are needed in a contract. We felt that this would be a great model for the counties to follow. It gave them direction and clarity on the terms that needed to be in a contract. It prevents the flat fee contract, and it's consistent with 180 Davis in our regulations.
And just to clarify, there was a comment about this doesn't apply to public defender offices, and nor does it apply to the urban counties. Is that correct? I'm following up.
It applies to individuals who contract for.
No. Oh, that's odd. Can you hear us?
I missed that a little bit.
Okay, try again.
Thank you, Madam Chair. Yes, this applies to individuals who contract for Indigent Defense Services. That would be the independent contractors.
Okay. Good. Can we move on to 43? Mr. Wells, a comment?
Yeah, I'm not sure it's sufficiently clear that it does what Jared just said. I think that's why our institutional defenders asked that question. So I don't have the immediate language to try to fix it, but I'm looking at the comments by them, and they write that's what their concern was. I'm thinking we need to make it clearer that it does not apply to those institutional offices in the larger counties.
Thank you, Mr. Wells.
Okay, so do we have, we can put that in. Okay, very good. So I think that's then 43.
Thank you. 43 is a relatively simple fix here. Basically, what we're doing is requesting that we do quarterly, at the county do quarterly billing, so we can track the Indigent Defense expenditures to track whether or not the state contribution is needed for conflict counsel.
Okay, and did you get no comments on that prior? Does anyone have any comments now?
That is correct.
So,
Mr. Wells.
I do have a comment to the extent if this is intended to apply to the larger counties. We actually don't allow quarterly billing except on what we define as our hourly cases, and only the complex ones there. Otherwise, we just take the billing at the conclusion of a case. It makes it easier to track the total amount of a case and the average dollar amount per cases. And we also found, interestingly enough, that if people bill quarterly on a case, the total amount of bill is actually larger than if they just bill once at the end of the case. And so we have limited quarterly billing, but we don't allow it on every single case.
Madam Chair, can we explain the reasoning for the quarterly billing rather than the end of the case? The differences between how state's budget versus county's budget, and I know Jeff Wells is far more understanding of this than I am, but my understanding is that the state budgets on a fiscal year, and generally the money has to be spent within that fiscal year. If we were to allow billing at the end of the case, that would it would complicate the maximum contribution formula. It could create stale claims where we wouldn't be allowed to pay for those out of the money that we have in our account. We might have to send it off to have it be a stale claim if it's outside of the fiscal year. So in talking with our budget analyst, we felt it important to request quarterly billing. So one example of this is in post-conviction cases. Although Clark County generally would like to have it at the end of the case for those billings, Clark County has started requesting that at the end of the fiscal year, telling their attorneys that they need to get the billing to us so that that bill can be processed within the fiscal year and be paid. Otherwise, the claim becomes stale and there's a large delay in paying those individuals. So this was just for budgetary purposes, to understand where we were with the budget and try and prevent certain items from going stale if it's being paid out of a state claim.
So, and we do that for you for the claims that are paid out of the state. We don't do that for our claims. If the bill comes in within what we always jokingly call period 13, and sometimes cases of period 14 and 15, we actually look at where the magnitude of the work was done to know which year to assign a billing to, which year to assign it to. So if we could just amend that sentence to say for things to be paid out of the state budget, I'm fine with that, and that'll solve both problems. We can continue to provide you the data you need for the state budget and not mess up what we're already doing at the county level.
Okay, that sounds good. Anything else on this? Good. There we are. I think we're at the end. So thank you, first of all, just thank you everyone very, very much for really hanging in there for a long period. But I think it was very productive, and I just really appreciate all the comments that we received for people who are still on and who've already left. Okay, I think we can move on to number 6, which is our future meeting, which is currently calendared for January 28th, 2021. That's our next meeting as a board, but it's also significant because it's the date, as we've mentioned, to adopt the regulations with a 30-day notice period. But that's when it makes sense for us to meet again. So that notice will be posted timely, and we still will have an opportunity at that board meeting to sort of circle back to some of these things that didn't get ironed out. So to the extent that we need to discuss those, we can do it then. So I think that's the date is firm. I think we've announced it before. And if there's any items to put on that agenda, you're welcome to mention them now, or obviously to email the department with them. Any suggestions at the moment?
Madam Chair, I do have a question about the timing of the next meeting. Because of the length of time that this workshop took, will 1 o'clock to 5 o'clock be sufficient time, or would you prefer to set the meeting at starting at 9 a.m.?
Let me just look at my calendar really quick. My sense is that we will be quicker, that we've really narrowed it down to a few items for that meeting. So I think the afternoon will work, but I'm open to hear what others have to say. So that's a Thursday.
I agree with the chairwoman. I don't think this is going to take nearly as long, particularly if Marcy and her team, and while I'm talking, I want to compliment them on all the hard work and the fact that they've listened to everybody and entertained all the comments. But if they send out a new version rough draft ahead of time so everybody can review, I really don't think it's going to take us nearly this long to go through it next time.
Right. So I think we've identified a few areas, and I think one, they might be resolved by then, or at least teed up for discussion, and then we can focus on that. But just from my sense, I think it's, we've probably got one big one with 48A, and then just a handful of others, and I think we can get through it. So, and I think generally afternoons are better for people, so, and certainly better for defenders, et cetera, or people who are going to court. So I think we'll stick with that. And again, any agenda items, if you think of them, please get them to the department. So moving on, we have another opportunity for public comment, limited to 3 minutes, if anyone would like to weigh in. And before I get there, I wanted to say two things. First of all, many thanks to Marcy and Patrick and Jared for really doing a fantastic job with just a lot of work over many months, really sort of the better part of the year, but then also in the lead up to this meeting, really spending time with people in the community to iron out these issues and hear them. We really appreciate that. There also was a comment mentioned earlier by Mr. Lister about the death penalty. So I actually just wanted to comment to that briefly. I don't think that this board or the department has any particular view on the death penalty. I think what our discussion earlier was responsive to the possibility that building in, as we sort of as we create regulations that change the funding mechanisms, that kind of adds new pressures and dynamics, which people are very concerned about. And so they're trying to kind of neutralize those dynamics in terms of incentivizing death penalty charges. Obviously, the mission of the board and the department is to get people good quality defense counsel when they need it. So that's where our focus is. And I think anything specific to the death penalty is sort of beyond the scope of what we're doing. And obviously, I assume that individual members' views on the death penalty on the board really vary. So I just thought that was worth mentioning. Okay, public comment? Anyone? Still hanging on?
Warm down.
Right. Okay, hearing none, would anyone like to move to adjourn?
Have a happy holiday, Kwanzaa, Hanukkah, et cetera, et cetera. Stay well, wear a mask.
Okay, all in favor of adjournment, say aye.
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 Any opposed? I can't imagine. Okay. Thank you, everyone, for giving so much time to this important topic and for, all of the help. It's really valuable.
Great job, Chairman.
Yeah,
Thank you,
great
guys.
job. And
Good
nice
job.
job.
Thank you all very much.
Good job.
And Mr. Wells, could you possibly get more experience to help us in the future?
I'm already 106.
Thanks.
Thank you.
Stop the recording.
Hey, Cindy, can you stop the recording, please? And, oh, she just left.